I am Amanda Apolloni. I am the Development Director for the Parkinsons Foundation Georgia chapter. Today is our program Planning for the Future, Tips from a Georgia Elder Care Attorney. We want to thank all of our sponsors today: Accorda Therapeutics, Amneal, Supernus, which is formerly known as US World Meds, Kyowa Kirin, and AbbVie, who have made today's program possible. The Parkinsons Foundation hosts virtual events each Monday, Wednesday, and Friday. To learn more and to register, please visit parkinson.org/pdhealth. We can add this link into the chat. You can also visit this page to view any of our archived PD Health events that we've had since we started our events here. The mission of the Parkinsons Foundation is to make lives better for people living with Parkinson's disease by improving care and advancing research today until there's a tomorrow without the disease. In everything that we do, we build on the energy, experience, and passion of the global Parkinson's community. We provide free resources, including our website, parkinson.org, educational book series, webinars, podcasts, our hospital safety kit, which is the Aware in Care, and our toll-free helpline, 1-800-4PD-INFO, which is staffed by Parkinson's specialists. We invest more than $10 million annually to support the most talented minds in research to explore what causes Parkinson's, how to treat it, and ultimately how to cure it. We recently launched a very exciting initiative called PD Generation, which provides free genetic testing and counseling to those with a Parkinson's diagnosis. To learn more and get further information, please visit parkinson.org/PD Generation. Our Parkinsons Foundation Georgia chapter supports people with Parkinson's and their care partners through our 2 local centers of excellence, Emory University and the Medical College of Georgia. We guide people with Parkinson's to safe and effective Parkinson's fitness classes through our PD Gladiator Fitness Network. We host educational programs just like this one that we bring our local community together annually at Moving Day Atlanta. This year's event will be a virtual celebration of movement on Saturday, October 17th, and we hope to see you all there. For more information and to register, visit movingdaywalk.org. For information on local events and resources, please visit parkinson.org/Georgia. You can also call our national helpline at 1-800-4PD-INFO with Parkinson's related questions. Today's program is being recorded and will be emailed out to all of those who are registered in about a week or so. So make sure you stay tuned for that. So without any more hesitation, it's now my pleasure to welcome today's speaker, Kelley Napier. Kelley Napier is a partner with Brannon Napier Elder Law in Atlanta. She focuses her practice on estate planning, elder law, and special needs. Kelley, take it away.
Thank you, Amanda. Before we get started, I would like to learn a little bit more about those of you who are watching today. We're going to put up 2 poll questions on the screen, and you can take a minute to answer the question right on your computer or device. Don't worry, all your answers are going to be anonymous. So our first question is, have you completed an advance directive for healthcare? All right. You guys have blown the average out of the water. The average for folks I talk to is about 30% of people have done so. We're up at 74% of you have completed an advance directive. Even the national average is only about 60%, so excellent work. Our second question is, have you completed a financial power of attorney? So we've got a slightly lower percentage here. Only about 56% have answered yes to this one, which is okay. But the financial power of attorney is the most important of documents that you can possibly have. So I'm going to strongly encourage the other 44% of you to get a power of attorney in place sooner rather than later. So when we talk about estate planning, that's going to be the basis of today's conversation. Estate planning, typically people think of 3 documents: the financial power of attorney, the advance directive for healthcare, and a will. Those documents are very important, but I'm going to talk about the 3 C's, which is creating those documents. Yes, that's important. Communicate, which is talking to your team and your family and your care partners about who's going to serve in various capacities and what you want in your documents and what kind of care you want as life moves forward. And finally, coordinate, which is both coordinating your team and coordinating your assets. So we might even be able to avoid probate. So our first C is create. So the things we want to create are those 3 documents I mentioned. We're going to start with the advance directive for healthcare because such a large percentage of you have it. We're not going to dwell on this one too long. Georgia created our advance directive for healthcare in 2007. So it's been around for about 13 years. It takes a living will, a healthcare power of attorney, and combines them into one document. So I recently saw somebody who had just moved here from Texas that actually had 4 documents that were all tied up in our Georgia Advanced Directive for Healthcare. So I'll tell you what it does. It lets you name people to talk to your healthcare team and help coordinate your care. Then it lets you tell them about your wishes for your body after your death. Do you want your brain or your entire body donated to research? Do you want to be cremated or buried? All of those, what happens to your remains questions are covered. Then it has what we usually refer to as a living will. It's the page where we're going to talk about end-of-life healthcare wishes. So these times with COVID-19 have definitely changed the way that we talk about advanced directives for healthcare, because most living wills and Georgia's advanced directive all talk about pretty extreme end-of-life situations. If you have a terminal condition that's going to result in your death in a relatively short period of time, or if you have you're in a persistent vegetative state. So if you are permanently unconscious and not responding to your environment or external stimuli, do you want life support? Those are 2 pretty extreme scenarios. Unfortunately, we're seeing a lot of people these days with a 3rd scenario, which is they are very ill and they have contracted COVID, and life support, specifically a ventilator, will likely help them survive this disease. We're seeing right now about 2/3 of people are surviving ventilator. 2/3 of people who are going on ventilators are surviving currently in Georgia, particularly at Emory. So that is not terminal. And even though you may be in a medically induced coma, you're still responding, and the doctors expect when they reduce your medications, you'll be cognizant again. So it's important to have those conversations with your family over whether you do want that level of care if you contract this disease. So that's a big gray area that's not really covered in your advance directive. The other great thing about the advance directive is that the person you've named as your agent has access to your medical records. So it also serves as a HIPAA release, because by law in Georgia, your agent on your advance directive can access medical records. What if you don't have an advance directive? So for that 27% that hasn't filled one out yet, that's okay. What happens is your family can make those medical decisions at the point that you can't make them. So if you're married, your spouse If you're not married and have children, all of your adult children can make those decisions, but they have to agree. If they don't agree, you go on life support and stay on life support indefinitely. If you don't have a spouse or children, it's your parents. If your parents aren't around, it's all of your siblings. So you notice we've got big groups. I went to law school a little bit older. I was about 30 when I started law school. And when I was in law school, I would actually carry advance directives around in my backpack and give them to my 22-year-old classmates and say, fill this out. I went to law school downtown at Georgia State, and a lot of my classmates rode bikes downtown on busy city streets. And so the draw for them was, if you get hit by a car and wind up at Grady, your parents have to agree about your health care unless you fill out one of these and name someone specific to manage your care. So children on the advance directive have to agree, parents have to agree. The only person who can make a decision independently if there's not an advance directive is your spouse. If someone comes to Georgia and has documents from another state, even if they have those 4 documents I mentioned that my client from Texas had, they're still valid. So if the document you have is valid where you signed it, it's still valid here. If you have multiple documents like they do, I usually suggest that you consolidate and get on a Georgia Advance Directive just for the sake of having one thing to carry around instead of 4. So if something happens and you don't have an advance directive and your family can't agree, then we wind up filing a petition for guardianship in the probate court where you live, where a judge determines whether you're competent or not. And if you're not competent, the judge appoints someone, hopefully a family member, to make your healthcare decisions and decisions about where you live. So that's the advance directive. You don't have to have one. There's a default. Your family can make those decisions. It's important, though, so that you can say who gets to make those decisions. The next document is the financial power of attorney. You might hear it called statutory power of attorney, durable power of attorney, general power of attorney. All of those things usually refer to a financial power of attorney. This is the most important document that any of us can have because it lets us name someone to help us manage our financial and legal affairs, sign things for us, manage our bank accounts at the event that we're not able to. So financial power of attorney is the most important. We don't have a backup. If you don't have a financial power of attorney, and something happens and you can't sign for yourself or can't manage your affairs or can't communicate effectively with your bank or your financial advisor or your pension company, no one else, not even your spouse, can do that for you. So your family ends up having to go to the probate court and file for conservatorship. So guardianship, I mentioned before, that's over your person, where you live, what kind of care you get. Conservatorship is over your finances. It is time consuming to do either petition. Usually people apply for both guardianship and conservatorship. If you can't manage your finances, there's a good chance you're not able to manage your health care either. It takes, right now in most metro Atlanta counties, it takes about 3 months from the time somebody files that petition before there's a hearing and the judge writes an order that says that so-and-so can manage your affairs because you can't manage them anymore. So it's time consuming, it's costly. The court fees alone are over $500. And if you hire an attorney, that's on top of the court fees. So it's pretty expensive and time consuming. So just make everyone's life easier. And right now, while you're able to make those decisions, go ahead and fill out a power of attorney. The power of attorney is only as good as what it says. So no matter what state you signed your power of attorney in, if it says my agent can manage my banking, my agent can sell my house, My agent can sign contracts for me. My agent can plan ahead for Medicaid benefits for me and help save some of my money. Then your agent can do it. If it doesn't say that, then your agent, the person you've named, cannot do that thing for you. So people often ask, I'm moving from out of state. Like we've got, Sally asked about her parents moved here from North Carolina. Their documents are perfectly valid. The problem is their documents may not give you very much power. So when someone moves, it's a good time to review the documents and see what powers they include. They may be perfectly fine. I looked at documents yesterday for a family from Hawaii. They were perfect. There was no reason to change any of them. I often look at documents. I also saw documents yesterday from a family who was right here in Georgia when they signed them. And they didn't include very much power. And unfortunately, when they were signed, they weren't valid because it requires a witness and a notary in Georgia to sign a power of attorney. And the ones this family had filled out had no witnesses. So their documents weren't valid. So power of attorney, the most important document. You can access the financial power of attorney online at Legal Aid. So Atlanta Legal Aid has the statutory power of attorney available on their website. However, Georgia's standard statutory power of attorney does not allow your agent to do planning for Medicaid. So if you're trying to plan ahead and get Medicaid benefits or plan ahead and get benefits from the Veterans Administration, you need to use an elder law attorney, not an estate planning attorney, an elder law attorney, so that they will have anticipated the powers you need to be able to preserve assets and the powers you need to be able to plan ahead to qualify for those public benefits. If you are financially wealthy and able to self-pay for your care for the rest of your life, then the statutory form off of the Legal Aid website is probably sufficient for you. And I forgot to mention, Georgia's Advanced Directive for Healthcare does not require an attorney, does not require a notary. It just requires 2 witnesses who will not inherit from you at your death. So typically 2 people who aren't family. And you can get that if you Google Georgia Advanced Directive for Healthcare. The very first option that pops up is the Georgia Department of Aging. And I think we also are going to post that link in the chat where you can download the Advanced Directive for Healthcare and complete that on your own. No notary, no attorney needed. Somebody asked about witnesses. So Georgia, our governor said that we can witness things virtually now. So via Zoom, you can meet with an attorney and attorneys can witness things. However, the governor didn't spell out how we sign those things very well. So our practice is incredibly conservative around making sure things are signed properly. So we're not currently signing things virtually. So what we're doing is meeting with folks in our parking lot. So you stay in your car, we stay outside your car, and we interact as little as possible. And that way we can watch you sign and meet the statutory requirements of witnessing without interacting very much at all, just for the sake of passing the documents. The governor did say we can witness things virtually, but it's not clear. Some attorneys are doing it, so that option is out there that some attorneys are helping families sign things virtually via Zoom or FaceTime. The last document when we think of estate planning is a will. You do not have to have a will. The state has a default. If you don't have a will, everything you own gets split equally between your spouse and children, but your children don't get less than 1/3. So for example, I am married, I have 2 children. If I died today without a will, my spouse, my 1-year-old, and my 4-year-old would each inherit 1/3 of my estate. That's not ideal. That's not what we want most of the time. So I want to have a will that says if I die today, everything goes to my spouse. And only if both of us are dead do things go to our children. And in fact, our children are too young to inherit things in Georgia. So my will says if both my spouse and I die, that everything is going to go in a trust for our children until they're old enough to manage it, which I think is older than 18. Me at 18, owning everything I own today, would not have been very responsible. And I was like a really nerdy, responsible kid. So the trust for my kids goes older than 18. You can pick whatever age you want. Most of you, just looking at the folks I can see on the screen, look like you don't have little kids. Maybe you have younger grandchildren at this point. So your will might say everything to my spouse, then everything equally to my kids. But if one of my kids dies before me, their share goes to their children. We see that a lot. And so for those grandkids, we might have that trust that says until they're 18 or 25 or whatever age you think, someone else is going to manage their money. Here's the beauty of trust, is that we get to, when we create the trust, so when we draft your will that includes this trust, we get to say what the terms are. So the money can be used for their health and education is a pretty common thing. So the trustee can pay for their school out of it, make sure their health care is covered out of it, even though we're not going to let our 4-year-olds or our 1-year-olds or even our 18-year-olds manage the money. So the trust for minors is one kind of trust. Another kind of trust that often we end up using when we have someone with Parkinson's disease is a special needs trust. So in one spouse's will, usually the spouse without Parkinson's, we say, when I die, anything I leave to my spouse who does have Parkinson's and will likely have high long-term care costs in the future is going to go into a special needs trust. And anything in this special needs trust does not count if my spouse ever applies for Medicaid in the future. So this is a way, even though we have a married couple, that we can preserve some assets if our spouse without Parkinson's dies, and protect things for the spouse with Parkinson's. You can also use this for any other person in your life who you're expecting to have high long-term care costs or who already has some sort of public benefit due to a disability. So if we have a child or a grandchild who we already know gets Medicaid or is going to be on SSI, we would leave their share to that same sort of special needs trust so that anything in a special needs trust does not affect Medicaid eligibility, does not affect SSI eligibility, and typically doesn't affect any eligibility for benefits through the Department of Behavioral Health or developmental disabilities. So anybody who we know is relying on government benefits for care or housing sometimes would be protected using a special needs trust. And that just fits right inside your will. So trusts inside your will are called testamentary trusts. So the trust doesn't do anything. You still own your assets until you die. Then whatever passes to them under your will goes into that special testamentary trust. Those are reasons you might want a will. As I mentioned, you don't have to have a will. Things go to your spouse and children equally if you don't have a will. Either way, things are passing through probate. So probate is the process where we take things from someone who has died and give them to someone else. If you don't have a will, they go to your spouse and children. That's called administration. If you do have a will, they go to the people who are listed in your will in the way it's described in your will. And the person who's in charge of that is called your executor. So that wills don't avoid probate. The only way to avoid probate is to use some sort of trust and put your assets in a trust now while you're alive. The kind of trust we most likely are going to be using is called a revocable living trust, revocable, which means you are in charge of your money while you're alive, and you've named additional successor trustees who, if you can't manage it, that they would manage it for you according to the terms you created in your trust. And then when you die, since your trust already owns your assets, your trustee just distributes everything according to the terms you created in your trust. So revocable living trusts are a great way to avoid probate. They don't provide us any asset protection when we're talking about public benefits, though. So those are the documents we're going to create. Then we have to communicate our wishes and where those documents are with our team. I will tell you, one of my biggest pet peeves is people who keep these documents in a safe deposit box. And they're the only person with access to that safe deposit box. Or maybe you and your spouse are the only people. If you are incapacitated, no one else can access your safe deposit box at all. There's no petition we can file, there's no law we can use for somebody else to gain access to a safe deposit box unless they have the key and their name is on the signature card. So my father-in-law is a very prepared man, and every time we go visit him, he takes us to the bank to make sure that we still are on the signature card, because he's a little worried that somehow the signature card will get changed to remove us, and to make sure that we still remember where the key is in the emergency box and can get into his safe deposit box, because that's where he's chosen to keep his documents. I'm going to encourage, if that's where you keep your important documents, that you do the same thing with someone other than your spouse, is take them to the bank, put them on the signature card, and make sure they know where the key is. Once you die, we can file a petition in the probate court to get permission to open your box if you haven't done that. But it doesn't do us any good while you're alive. So we can't get your power of attorney and act on it if you've stored it there and we're not on the box. The other things you want to communicate are around healthcare. We talked about that a little bit already. I tell on my family a lot. My mom filled out an advance directive for healthcare 10 years ago because she was going to have open heart surgery. My grandmother had moved into assisted living a few months before this happened, and so we had updated her documents. My grandmother had been a hospice volunteer, so she had these documents. She knew the value of them, but we had updated them because I was now the person really managing her healthcare. So we changed her documents to make sure it reflected that. So we had just gone through an advance directive, just had these conversations with my grandmother. And I thought we were all on the same page. And then it became time to fill out my mom's advance directive. My mom is not particularly healthy. She was having open heart surgery at age 60. And this was not the first, the second, this was more than the 10th surgery she had had since my parents had been married. And we found out my parents had never talked about their wishes with one another. They did not know what the other person wanted as far as end-of-life health care. And we all found out that none of us knew what my mom wanted. We all, based on conversations, my grandmother had dementia at the end of her life. Her grandmother had dementia at the end of her life. We thought we knew what my mom wanted. She had told us a lot about her thoughts and feelings around living with her grandmother who had dementia, living with her mom who had dementia. And it turns out none of us knew. And so we ended up with a lot of tears as the 6 of us sat around the table trying to fill out my parents' advance directives for healthcare. So have the conversation and have it often, and talk about mental incapacity as well as physical incapacity. Because people, I found out the hard way, have very different feelings around those two different kinds of incapacity. So communicate with your team. Tell them where the documents are. Tell them what your wishes are. Tell them what you own. This is another thing about my parents. My parents are very private. I know the physical things they own, and I know their financial advisor, and I know their banker, but I have no idea what my parents' net worth is. They are not open about that and do not want to share that with us, which is fine. because my mom has a folder in her safe next to the powers of attorney that she has showed me. And every year she goes through and she takes one statement for each account they have and updates it in that folder. So I know in the future, when I need to help them manage this or when they die, that I can go to that folder and see what they own. I can see what the bank accounts are, and I can take that folder with me along with the power of attorney or the will, depending on if they are incapacitated or if they have passed away, and manage their affairs. So even if you don't want to tell people exactly what you own, tell people where to get the information. A lot of clients ask me about where they should keep their login information for their accounts. I don't generally think you should keep that all written down somewhere for someone to find unless you need it all written down somewhere. If you need it all written down somewhere, absolutely do that. But it's a little dangerous to have all your login information present somewhere. What I typically suggest is make sure that someone can access your primary email account, right? Every time you create a new account somewhere, they ask for your email and send you a verification code. So if people can get into your email, they can access all of your other accounts because they can reset all your other passwords. So that's the safest way to make sure folks can access all your online accounts. We've had somebody ask about the power of attorney. How is it different for planning for Medicaid versus just the general power of attorney? The biggest difference is that the general power of attorney says that your agent cannot give away any of your assets. And for Medicaid planning, that's what we're doing a lot of times, is we're creating a trust or creating a gift to preserve some of your assets. Whereas, and then we're often loaning some of your assets. So creating a loan with a trusted friend or family member where you are transferring assets to them and they are paying you back on a regular basis, which is not a power that your agent has under the regular statutory power of attorney. So those are things that have to be added. Also, we recently had an issue with Wells Fargo that they won't let the agent under a power of attorney access a joint account. So let's think about that. You and your spouse have a joint checking account. Something happens to your spouse, and then something happens to you, and now you can't, your agent under the power of attorney can't access that account and use it to pay your bills, which is, what you want your power of attorney to do if something happens, because you and your spouse are joint on that account. Even if you and your spouse both had the same agent, an adult child, for example, named, they still wouldn't be able to access that account if it was at Wells Fargo. So those are the sorts of things that elder law attorneys are used to dealing with incapacity in a way that estate planning attorneys are usually planning for your death. And so they're not thinking about these incapacity and access and care issues. Our last C is coordinate. Make sure your beneficiary designations are correct. You can name a beneficiary on everything you own except your house. So your bank accounts can have a beneficiary. Most banks call it POD for paid on death. Your investment accounts can have beneficiaries, stocks and bonds. Even savings bonds you get from the Treasury can have beneficiaries on them. Your IRAs, 401ks, 403bs, thrift savings, whatever other retirement account you have should have a beneficiary, and it should be a living, breathing person most of the time. There are very rare exceptions to that. Life insurance should have a beneficiary named. All of these different things you own can have beneficiaries. You can't put a beneficiary on your house, unfortunately. You can have joint owners, but I usually do not suggest that you add your child as a joint owner to your account as a way to avoid probate, because then your child owns your house or owns your account. And if something happens and now they've had an accident or they have creditors, your thing you just added your child's name to is available to their creditors, which is really problematic for you. So usually we don't suggest adding kids to your accounts or kids to your house. The Parkinsons Foundation Helpline has provided some questions that folks have asked us about that they get often. So we're going to cover those questions from the helpline here for a few minutes. The first question that they get is about guardianship. So we mentioned guardianship and conservatorship earlier, and I told you why we want to avoid them, because it's costly, it takes a while. But that actual process is that you file the petition, the court sends an evaluator out to evaluate the loved one that you have said needs a guardian or conservator. And the evaluator is trying to figure out their competency. Can they make significant responsible decisions about their health care or about their finances? Then there's going to be a hearing. The person you're trying to get the guardianship over is named a ward. And so the court is going to appoint an attorney to represent the ward at that hearing. And then at the hearing, there's going to be testimony about whether or not that person can make their own decisions. If the person is very incapacitated, particularly very physically incapacitated, then their attorney will often waive their need to be at that hearing. But there are some judges, even local Metro Atlanta judges, particularly in Gwinnett County, that want the ward to be present almost no matter what. Right now, in most counties, these hearings are happening virtually, so they're over Zoom. But there are some counties and some situations where they still want it in person. So there's going to be a hearing in front of the judge where you say, this is why this person needs a guardian, and this is why I should be their guardian. The rest of our questions are really all about Medicaid. So let's talk about Medicaid for a minute. To qualify for Medicaid in Georgia, you have to have less than $2,000. If you are married, your spouse has to have less than $127,000. So we're at right around $130,000 for a married couple if one spouse needs Medicaid. Let's also talk about, what does Medicaid pay for? In Georgia, Medicaid pays for nursing homes, guaranteed. If you're in a nursing home and you've met the financial eligibility for Medicaid, you can apply and you will be covered. We also have a home care program to help pay for some home care, not 24/7, usually about 40 hours a week or less of home care is covered under Georgia's Medicaid. But that program is not always funded. Right now, today, we do not have a waiting list, but a lot of times we do have a waiting list and people are not guaranteed Medicaid coverage for home care. Medicaid in Georgia does not cover assisted living at all, ever, under any circumstances. Medicaid in Georgia does cover some small personal care homes. So by small personal care homes, we mean usually residential houses in a community, so in a neighborhood. They have 10 to 15 residents at most. Some of those are covered under that same home care program. So the funding's not always guaranteed. Currently, there is funding available for that, though. So to qualify, you have to have less than $2,000. There's things that don't count towards that $2,000. Your house does not count towards the $2,000. Your checking account does count. One car does not count. Your retirement accounts, IRAs, 401ks, 403bs do not count. However, you have to take distributions. Even if you're under 72, you still have to take distributions if you want to qualify for Medicaid, and the distributions count as income. And life insurance in general probably doesn't count. It depends. You're allowed to have up to $10,000 set aside for burial, which includes some life insurance. So that's worth calling a lawyer to figure out your life insurance issues. There's about 30 pages in the Medicaid manual. It's 3 separate sections that cover burial and life insurance, so it's worth just calling, getting that official advice. So anything you own, basically other than your house, 1 car, retirement accounts, and some burial things, counts towards that $2,000 limit. So it's hard to get qualified if you're single. If you use an elder law attorney, we can usually help you save around half of whatever you have left if you're single. If you're married, we can often help you save most, if not all, of the assets for the spouse who's not going in the nursing home. So there's planning options. Georgia's pretty generous with our married Medicaid applicants. The next piece is income. So I mentioned IRA, 401k distributions, those are income. Also, your income is Social Security, pensions, anything, any money that comes to you on a regular basis, even if it's not monthly. Maybe you get some sort of quarterly income. That's income for Medicaid purposes. That we have a few clients who have had injuries and get a workers' comp settlement. And so they get an annual income from the workers' comp. It's just 1 payment a year. It's still income. So income is any money that comes to you. The income limit for the person in the nursing home or the person on Medicaid is $2,349 per month. So if your income is less than that, great, you're qualified for Medicaid. If your income is more than that, then you have to have a special checking account called a qualified income trust to qualify for Medicaid. It's literally, we're just going to wash your income through this trust every month so that your income's magically below the limit and now you have qualified. If you are married, your spouse never has to pay their income for your care if you are on Medicaid. So hear that. If you are married, your spouse never has to pay their income for your care if you are on Medicaid. And if your spouse has less than $3,216 a month in gross monthly income, they get to keep some of your income to bring them up to that $3,216 threshold. So we work with a lot of families that the 2 spouses together have less than $3,000 a month in income. So the spouse who's not in the nursing home gets to keep all of that family's income, and they pay nothing to the nursing home. Otherwise, let's say we have a single person. If you're in the nursing home, you get to keep $70 a month of your income. That's your spending money. And you get to use your income to pay all of your health insurance premiums. Whatever's left after your 70 and your health insurance premium, you pay to the nursing home. That's called your patient liability. So, even if you're on Medicaid, typically you have a patient liability, so you have a cost share to pay for your care in that nursing home. Transferring assets, no. If you transfer assets to anyone other than your spouse or a disabled child, Medicaid will penalize you for that. And they look back 5 years. So currently our penalty is $8,517. So if you give away $8,500 today, if you apply for Medicaid anytime in the next 5 years, Medicaid will say you are not eligible for 1 month because you gave away that $8,500 today. So transferring assets, if you plan ahead, you can absolutely transfer assets. But if you do not plan ahead, anything you transfer will create a penalty. So I mentioned earlier the planning we would do might be create a trust or gift money. We do that intentionally, creating a penalty. And then we also loan money to create an income stream so that you have sufficient income to pay for your care that Medicaid's not going to pay for during the term of that penalty. So it's a little bit complex, the planning, but a good power of attorney gives us the ability to do that planning and preserve some of your assets. And then our last question, I have like 30 seconds left, is what do we do about family dynamics? The best thing we can do are those 3 C's back from the beginning. We want to create good, strong documents that make it clear who's going to be in charge. And we want to communicate with everyone. We want everybody to know what the plan is. We don't want surprises later. And we want to be very clear who's going to be in charge of all of these documents. So that wraps us up. Amanda, I think, has some more questions, and we've got a couple more in the chat that I'm not sure we have covered yet.
Let me unmute myself there. Yeah. Did you want to go ahead and answer the ones in the chat? And then if we had any other questions, I can certainly ask you those.
Yeah, so Sally, the $2,000 is an asset limit. That's everything you own. Salary would be income, and the income limit is $2,349. And yes, inheritance is income in the month it's received. And if you own that, if you don't spend the money in the month it's received and you still have it the next month, then it's an asset the month after it's received. So then you would not only have the income issue in the month you received it, but then you have an asset issue the next month. So that's why we talked about special needs trust planning. If we have somebody that we know is going to need Medicaid later, is we don't want them to inherit. We want their money to go into a trust. Savings accounts are assets. Anything you own, investments, stocks, bonds, anything that's not in a retirement account is an asset other than your house. And yes, even if somebody is already on SSDI and Medicare, we can absolutely do trust planning. We just have to talk about pros and cons and whether you've got 5 years before you think you're going to need this kind of Medicaid covered care. Other questions?
Let's see. Okay, so I just got one that came in that says, are there any additional COVID-specific considerations or benefits that we should be aware of right now? Should we update our documents pre or post-COVID?
Does not matter at all. If you want to update your documents, now is the time. Don't wait. We can find the safest way possible to help you get those documents signed. We've even done some window signings for folks who are in facilities or even one family at a house where we stood outside the window and watched them sign things, and the witnesses stand outside with us. So most attorneys in this area are taking as many precautions as possible. So now's the time. As far as COVID specific planning, there's not really any unless you wanted to add language to your advanced directive for healthcare around what happens if you have a viral infection or have pneumonia and needed a ventilator to help you get through that disease. Otherwise, no, the COVID stuff is really about communication. But now it has definitely made it more important for folks to make sure they have good planning in place, because we have a lot of clients who are very isolated in their assisted living facilities and even in their independent living facilities or at home, because it's just not safe for them to be out in the community because of other pre-existing conditions.
Thank you for answering that. The second question here is, how much preparation is required on my part before meeting with an elder law attorney?
Not much. We send out, it depends on the attorney you use, but we send out a little 2-page worksheet. The first page is who are you and who is your family, and then contact information for those people, you and your family. The second page is what do you own? And it's pretty general. Checking accounts, savings accounts, brokerage accounts, businesses. I don't usually need to know the exact amount unless we're planning for Medicaid or planning for veterans benefits. If we're just doing estate planning, then I need to know the kinds of accounts and any joint owners you have on those things so that we can make sure we're addressing everything in beneficiaries and coordinating all those things as much as possible. You also need to have a general idea, but you don't have to write this down, about who you would want to serve in these different capacities. We're seeing a lot of what the news is referring to as orphaned elders. So folks who don't have children and maybe are not married and don't have great support systems. This is a national issue now, but those folks, it is hard sometimes. You might not have someone to serve on these documents for you. If so, there are professionals that you can hire to serve in these various roles. There are daily money managers who can be your financial power of attorney, and there are aging life care managers who are care managers who can be your healthcare agent.
And for those who are struggling to pay bills, are there ways to get legal financial assistance?
There are some assistance programs out there. So if you're struggling, there's lots of options. If you're struggling with medical bills or prescription bills, Medicaid might be available. We do have a very limited class of Medicaid. If you are on Medicare, called QMB, that has an $8,000 asset limit that lets Medicaid pick up your copays, basically, for healthcare. That's all it does. It doesn't pay for care, it's just for copays. So that's an option. If you're struggling with your regular household bills, a reverse mortgage might be a good option. If you still have mortgage payments, a reverse mortgage is like your regular mortgage, except you don't have mortgage payments anymore. The bank knows that they have to wait until you die or move out of the house, and then they'll get paid out of the sale proceeds of the house instead of you making a regular monthly payment. Georgia Power has assistance programs for people who use Georgia Power for their electricity. Most of the EMCs also have some sort of assistance programs for folks who can get a grant from their electric company to help cover their electric bill. Food stamps, it's called SNAP or EBT. You can get those benefits through your local DFACS office. You can also get Meals on Wheels from your local senior services. So your county has a senior services, and you can contact them about Meals on Wheels. In the metro area, Meals on Wheels has seen the need just mushroom during this time. It's been so big. How much more the need has been when folks can't get out and get to the grocery stores anymore. You can also, actually that's a really good point, you can also call the helpline. So the Parkinsons Foundation has a helpline. I believe they're open business hours, Monday through Friday business hours, and you can call them and get connected to a lot of these resources as well.
Absolutely. And then this next question here really has kind of two parts to it. So do I need to bring my family members and beneficiaries to the attorney meetings? And how often should we meet with an elder law attorney?
You definitely don't need to bring your beneficiaries. It is often helpful if we've got at least the agents, so the people who are going to serve for you, or if we're anticipating, back to that earlier helpline question, what do we do about family conflict? If we're anticipating conflict, let's get everybody involved. Let's have everybody on the call. So these days it's mostly virtual. So we would all be on a Zoom call like this one, talking to each other. So yes, the more ears, the better a lot of times. The person who's going to be your agent on your financial power of attorney does have to sign your financial power of attorney. So that person needs to be involved, at least to the extent of signing, to know that they're taking on that power. And then somebody has asked us if the executor can be the financial power of attorney. Yes, you can have the same person serving in any of these different roles. And you also want to make sure you have more than one person. So you've got your first person. If you're married, a lot of times that's your spouse. Then you need to have backups. And I want everybody to try to have 2 backups other than their spouse. That's a big deal, is we want to make sure we have backups so that if something happens to your first person, you're not having to redo these documents all the time. And yes, you want to see your elder law attorney when you have family changes. So now get your documents in place. If a spouse passes, we need to talk about what happens next. If somebody gets a new diagnosis or has a care transition, it's a good time to check in with your attorney and make sure everything's headed the right direction. There's not a every year or every 2-year rule. It's just when you have changes. And I think that wraps up my time, Amanda. I think I'm going to turn
let's see here.
back over.
Yeah, so we had one more come into the chat here. And then I believe that is our final question, unless you have any last tips or tricks or anything. But I believe that last question there is the last one.
If we create a trust and then somebody needs care in 3 years or 4 years after we've created that trust, we just have to look at the situation and find out, is it better to wait until we've made it to the end of the 5 years, so pay for care for whatever time period's remaining till we've hit that time? Or is it better for us to undo the trust and do a different sort of plan? If it's a married couple, a lot of times undoing the trust is better. And occasionally, depending on how severe the disease progression is already, it might be better just not to create a trust in the first place and just do other types of planning to get ready for when that nursing home level care is going to be needed in the future.
Awesome. Well, a huge thank you to you, Kelley, for walking us through this and really educating us and on this. So thank you very much for your time. And thank you to all of you who were able to join on today's program. I wanted to give another special shout out to all of our sponsors. This is from Accorda Therapeutics, Amneal, Supernus, Kiowa Kirin, and AbbVie, who are today's sponsors to make today's program possible. You can learn more about them by visiting parkinson.org/events/2020/eldercaregeorgia. They also will be featured in our email that we send out. We hope that we get to see all of you at some of our upcoming events. For more information on our national programs happening each week, please visit parkinson.org/pdhealth. Stay tuned for a special program in October, and please get you and your team members registered for our Moving Day Atlanta event on October 17th. You all will receive a short survey by email after today's program, so please take a minute to complete that survey. We'd love to know what you guys thought today and what else you would like to learn about. We will also share a recording of today's session once it's available. And a recording of today's program will be emailed out in about a week. So please stay tuned for that so you can share it with other people who might benefit from this information. Thank you guys all again for joining us today, and please stay healthy and stay safe.